In this short presentation, I'll be going through a set of slides in relation to the firm in law as part of the course of Enterprise and Governance in the School of International Liberal Studies at Waseda. And students have already the slide set, so I'll be speaking fairly quickly to the key issues, just simply emphasizing some of the overriding concepts that we will be developing in subsequent weeks. So, as our textbook makes abundantly clear, some of the key terms and the concept of the corporation, bringing people together to contribute capital and to share risk, particularly to be able to engage in larger scale enterprises than they can do by themselves. This has quite ancient origins, and the text and our previous set of slides and presentation speaks to us about that. But very significantly, the establishment of the corporation in law is a recent phenomena. There are some legal precedents, very, very tentative ones way back in the Roman Empire period. We then see in the Middle Ages, and I will talk separately about this in another context, the creation of charters and organizations for a whole range of communities that would be effectively authorized by the power of the day, particularly the crown, the king or the queen. And this could be a charter literally to establish a town, and to some degree a self-governing town, a community of specified members with certain responsibilities and rights, for example, including, for example, local taxation of economic activity in the area. It might have been, for example, a trade guild, the establishment of a university, for example. So we see various body corporates. So these are legal entities which creates a body very significantly in some sense of perpetuity. That the problem with the human body, of course, is that even if we live a long time, if we go to 114, which is my goal, that's still in the scheme of things not very long. Many of the great universities of the medieval era, the likes of Bologna, of course, of Sorbonne, of Cambridge, Oxford, date back to the 13th, 14th century, for example. And as a consequence, people have been long focused on how you have a degree of organizational continuity. It's about owning assets, creating structures for control, and literally going beyond the term of influence of any particular individual. So to offer a secure foundation for organizing social activities. Now, to use this as a general vehicle for doing business, this is a much more recent phenomena. The Crown would historically give a right, a charter to create a company to pursue a business activity that was very clearly specified, for example, trading with the new colonies in the Americas, for example, and in a subset of specialist purposes, for example, the Virginia Company to establish a settlement in what is now the state of Virginia. And each time you wanted to do something that had a different purpose, you had to create a new corporate form, or you had to get permission to change the existing articles of association, the corporate charter, from the Crown. So to develop this vehicle of the company that could be established without actually having to specify a very clear purpose and to seek, for example, parliamentary or royal approval is something that was really only formulated in a common way in the mid-19th century. And most strikingly, it happened in the United States, and we talk further about the rise of the American corporation. We'll get into the details of this. And the development, particularly with competition between various states in the United States trying to literally attract business to their own particular settlement, to their state, led to a certain competition, which led to innovation in the law. Someone would argue a race to the bottom. But in many respects, legally, it became literally a process of figuring out the best way to strike compromises, to establish the legal foundations of firms, so it worked well for business, to some degree protected investors, and tried to attenuate or diminish the worst potential problems of the corporate form. Once that evolved in the American context, some of those innovations were then imported back into Britain, and we see very notably, as was discussed in the opening of our textbook, the company, the creation of the Corporations Act, which then provided a template for many other countries as well to develop the regulation of the modern corporate form for business. So when we look at the history of the corporate form, it offers very deep insights into modernization, and a textbook talks about that as well, and we'll develop these themes later on. For example, the simultaneous rise of higher education and this notion of meritocracy, that you find the best and brightest people, particularly through fair exams and whatnot, and appraisals of people's performance, and that you have the best and brightest in managerial roles in the organization, and you separate the financing of the business from the management of the business, and that's in the interest of both the financiers and in terms of society as a whole, of putting more talented people in charge of economic endeavors. These are simultaneous developments. So they're organizational developments, they're legal developments, and they're cultural developments. The cultural aspects we will talk about very directly in class, particularly in the Japanese context, for instance, and think about our university, Waseda, how it grew in tandem with the rise of the modern corporatized industrial Japanese economy. So there's another aspect of this too, though, and this is actually the rise of the modern state as well. As the states became formalized and created national public services, for example, they also needed public servants, and so the universities played a role here. But also very significantly, and if we look at the history in Japan too, we see this, that in a context of imperialism and political and military rivalries between states, and the increasingly large scale and capital intensiveness of warfare, building modern warships and mobilizing mass armies and whatnot. Also, the state had a very strong interest in a strong private commercial sector, organized effectively in a sustainable way, and manufacturing at scale. So there were complementary developments of the corporate form, the modern large-scale enterprise, the modern large-scale state, and also large-scale education systems, initially primary and then secondary and tertiary education systems, that all were mutually reinforcing. And the rise of the mass military is another part of this, of course. So the organization of business itself, it can be on various legal bases. It can be a sole operation where you're simply self-employed, as the Japanese suggest, jiegyo, literally, you're self-employed. It can be organized on a partnership basis, and the partnership basis of business was very common before the widespread use of corporations, and continues to be very significant in some fields in professional services, such as in accounting services, medical services, architecture, design, for example. And indeed, in some countries, there was a very strong resistance to actually allowing those professional services to be offered through a corporate structure, particularly with limited liability. And we'll talk again further about why this was the case when we turn to the issues of liability. But simply put, there was a concern that, for example, if someone was in medical services, that a significant discipline upon them that kept them professional was the risk of being sued for professional negligence, and that limited liability would be inappropriate in that context. But there are also complex issues of vested interests. Established key institutions didn't want to see new ways of many of these services being organized, although we'll see later on that sometimes endeavors that have been organized on, say, a collective basis, a cooperative basis, members, stakeholders realize that if you turn it into a company and they become shareholders, that they may actually make some money out of this. They may actually have a once-off capital gain, and I will provide some examples when we talk about this in class. So there are lots of ways of organizing business, and still today we see that. Sole operations, partnerships, collectives, cooperatives, and various incorporated bodies, for-profit, not-for-profit. Now, the particular preferred form is very much determined by what you're actually doing. Simply put, if you're looking to raise donations, for example, to provide various cultural services to a community, a for-profit corporate basis isn't a good idea. People don't donate money to for-profit companies, okay? If, on the other hand, it is a gakahorjin or an educational foundation where its clear purpose, clearly specified, says that any revenues will be directed exclusively for the particular goals of the organization, educational services, people are more likely to tip in some money if they really believe that that vision is good and the particular organization will realize that vision effectively. Now, lots of small businesses in many countries are never done on a company basis because to create a company is time-consuming, sometimes with paperwork. It's often quite expensive. In Japan, until recently, you needed a minimum capital basis. So literally, you had to have a bank where you put a certain minimum capital requirement that was held in the bank under trust. The idea there being that people who are making a claim on the company could actually get their hands on that capital if the company defaulted in other ways. This actually made the bank central to the establishment of the creation of a company, and it still continues in the Japanese case with the master seal or hanko. Very interesting questions of digitization and the implication here. But this idea of linking the company to the bank became a very distinctive element we see that was in the early days of the creation of the corporate form in Meiji Japan, became a practice that emerged, reinforced by law, but isn't the same in other countries. So, in short, depending on the circumstances of the business, the preferred form is going to differ. Okay, partnerships, as I mentioned here, the slide here clearly shows, are still very common, but over time there is more of a shift to incorporation where the law will actually allow it to do it. But some of the very big consulting firms that you would know of very well, the Boston Consulting, for example, McKinsey's, EY, these all are on still a partnership basis and exploring the possibility of turning themselves into corporations. We do see some very famous financial institutions, once upon a time were organized as partnerships, but have evolved to actually be on a shareholder basis and actually to be traded as listed companies on the stock market as well. The really important thing that comes through so clearly in our textbook is the rise, the dominance of the limited liability corporation, having become the predominant organizational form for organizing most economic activity, particularly the raising of large amounts of capital for large-scale manufacturing, for example, in capital-intensive endeavors. Now, just a little bit of history to remind us, of course, corpus is Latin for body, so incorporation is literally creating a legal body, as our textbook talks about, a fictional person who cannot die, fundamentally. Okay, so a corporation is a mechanism established to allow different parties to contribute capital, expertise, and labor for their mutual benefit, and with a high degree of specialization. And we've seen Michael Jensen's definition already, okay? So I won't read through it again, but you can look at it, just the highlighted parts here. Critically, it's a nexus for a complex set of voluntary contracts. It's the loci of contracts, and this greatly simplifies the contracting process. You know, once upon a time in universities, it was very common for individual professors to set their own fees for lectures, and they would negotiate with individual students. Literally, they would say to some students, quite wealthy students, for example, this is my standard fee, you want to take my class, this is what it's going to cost. Okay, but you're a poor kid and you're super smart, I really want you in the class, I'll let you come for a penny or for nothing whatsoever, you can carry my bag or whatever. But of course, there are significant inefficiencies there. So it made sense for the universities over time to pay the professors a fixed salary and then to manage the financing issues directly between the students and the university. So literally the contractor becomes the university, and everyone who provides those services would simply contract with the university as a whole, and the university would have expertise in negotiating and maintaining contracts. I'm also inclined to think in the past that generally the wealthier students were aristocrats, and they were also allowed to wear swords. So your average professor, yeah, it wouldn't have been a very comfortable kind of thing, would it, negotiating with a student saying, your grades are pretty bad and I don't like your attitude, I'm going to charge you more than someone else, and they're wearing a sword and you're holding a piece of chalk. It's not a very desirable negotiation, that one. Okay, so what's the firm? Obviously, it's a legal entity. It's an artificial person. It's immortal. But it is very clearly an organizational personality and identity. Okay, we understand that. Companies very directly and deliberately communicate to communities at large, expressing certain values. They tell their stories of origins. They try and communicate what they do, their particular approach, their ethos. And part of this is about trying to attract good employees. Partly this is about actually attracting the goodwill of various stakeholders, whether it's regulators, potential clients, suppliers, and whatnot. So obviously bringing people together inside this organization, it's a site of collaborations, and it maybe, I think very often, is patterned by a very distinctive ethos or culture. And many students doing shukatsu, this is one of their big concerns. Even if they know what they want to do, if they want to go to a trading company, for example, what's the culture in one trading company compared to another? And so people try to go and talk to former Waseda students, Orbi or Hormone, for example, to try and get some sense of the culture, going to company orientations. But of course, companies themselves are trying to present themselves in a certain way, to make themselves look good. So, of course, a firm is a hub of purchases and sales. It is this nexus of contract, I said, but also critically, and when we looked at the framework provided by Lindblom on market systems, critically, it's also a hierarchy. When you bring all the contracting inside an organization, clearly that is centered on the leadership of the organization, and effectively you're creating a more or less hierarchical structure. Now, some companies, the culture of them, the history of them tend to be very hierarchical. Some of them tend to be very flat. Generally, we see a shift towards greater organizational flatness, and our textbook in later chapters talks about why. Increasing specialization of particular employees, for example, many factors at work. But also it partly depends on the industry. In more creative fields, you tend to have more flat structures. You really can't make people be creative by command. But in industries that are very much sensitive to quality control or fundamental safety issues, obviously running trains in a complex system such as Tokyo, for example, there is a lot of necessary kind of command and control that's happening. Large-scale manufacturing as well has very strong elements of command, control, and coordination. So let's think very briefly about the public persona of the firm. Okay, this has very strong legal foundations as well. Okay, now the legal name of the company may be different from how it actually presents itself out there. You've got the business names, the brands, the trademarks, web domains, all of these kind of things contributes to the public persona. There's a very strong legal foundation to these, and companies have to be very careful to make sure that they try and protect their legal identity. And it's a problem when you start off small in one country and then move to other markets, and you may discover that in other markets somebody else already owns that particular name, for example, that may be very strongly associated with your commercial identity. Nissan, for example, fell fell into the trap of being rather bullying, I would say, actually, in trying to get control of Nissan.com. The guy who owned the domain name Nissan.com was an Israeli-American guy, and Nissan is also a Hebrew word, and he ran a computer shop. He was an early computer maniac, and when the World Wide Net was first established, he registered Nissan.com for his own small business, and Nissan became a very large company and said, we're bigger, we should have the right to Nissan because we're bigger than you. Which is not very persuasive argument at all. So it went on and on and on for years. Okay, so we do have now mechanisms actually for registering business names across a number of countries, but it's a voluntary mechanism that a number of states have bought into to try and reduce the particular costs and contention around the expansion of businesses across national borders. This is a cute one. I like this. The Stars and Bucks Cafe. Starbucks hasn't been aggressive on this. This is actually in Bethlehem in the West Bank, in the Palestinian territories. You get there through Israel, of course, from Jerusalem. And so clearly Starbucks didn't want to be seen to be beating up the operators of the Palestinian operators of a cafe in the West Bank. But I'm sure if you tried to do a similar kind of thing in central Tokyo or New York, you would be very quickly sued by Starbucks. So business names, we tend to think that the registration of business names are all about protecting the rights of the company, okay? And of course, Starbucks, think of it in those terms. But historically, and this is the third point, the registration of the business name was primarily to protect people who would deal with the business. So if you buy something from, A and B Consulting, you sell services to XYZ Manufacturing, and then they don't pay you, you want to find out who you have to go after, okay? Because the great danger is that by using a business name, you can hide from your creditors, okay? So in my country, in Australia, any business name that you use whenever you do a business, you cannot just make up a business name. You can't just make up a name card or whatever and start doing business by it. It's completely illegal. You have to trade under your own name unless you have registered that business name. And it's an historical record, so you can go to a national register in Australia and you can check any business name, present or past, and find out who had that business name registered. You can also search by people, for example, as well too. Even really basic things like having a domain name registered as well. You can find past records of that through the domain registration system. Trademarks are a separate issue from the brand per se and the company name. And there's a whole bunch of things, and trademark law is very complicated and it's very country by country. We're not really going to get into it here, just simply to point out that these are very contentious and issues, but very significant to companies, because we know companies primarily through their public persona, particularly through their trademarks, through their brands. So logos, a whole range of things can be registered. In Anglo-American jurisdictions where the law is mutually influencing, precedents that are developed in the United States will often be referenced. They're not binding, but they're often quoted in, say, British or Australian, New Zealand, Canadian legal cases, and the court may choose to be informed by those particular cases. But a trademark can be a word, a phrase, a letter, a number, a sound, a smell, shape, or whatever. Okay, but it is normally highly restricted in terms of how it can be used. You can't just register the letter, the number 9, and say, okay, nobody can use 9 anymore. But in relation to a very particular product, for example, then it's conceivable. Very importantly, just because you register a domain name or a business name doesn't mean you give trademark protection. Quite separate, actually. So you need to go through separate registration processes. There is a bit of a defense in the Anglo-American law if you haven't registered all of your names, if clearly someone else is kind of pretending to be you. there's an old common law notion of passing off, of pretending to be something you're not, or passing it off as a say an original product. You sell someone a supposedly Egyptian antique, which might be problematic inherently anyway, but you've actually made it in a workshop, it's a fake, then that's a very clear breach of the passing off principle. So if people are faking your products, for example, or pretending to be associated with you and your business and they're not, you can take legal action for them in the Anglo-American context. And this is one reason why the British law has been particularly helpful for the development of international business. So the registered trademark gives you exclusive right to use, license, or sell it in a particular jurisdiction. Okay, but for the most part, general terms and place names are prevented. So some of you may have wondered about the Waseda Juku, okay, and what's that relation to Waseda? Well, Waseda University can't stop them using Waseda Juku because Waseda is also a place name. Now, ironically, the Waseda place name kind of came about because of the association with Okamashiga Nobu-san, the key founder of Waseda, but it is a place name. And as a consequence, there's no way that Waseda can legally stop other people using Waseda, okay? And I never cease to be amazed, actually, at how many interesting domain names, .coms and whatnot, around Waseda have not been proactively registered by Waseda. I would have been jumping all over them if I were, just to make sure that people weren't creating, wasedacomplaints.com or something like that. Don't register. Well, maybe you will. I don't know. It's up to you. Anyway, many companies will spend a lot of money on domain registrations trying to anticipate domain jacking, for example, where people will create domains that are easy to remember that people might land on, which is a site that would be either misrepresenting themselves as associated with the company or sometimes actually criticizing the company quite strikingly. Now, the trademark protection mechanisms, the Madrid Protocol is what you need to know. So it's, there's a typo in here, sorry. This Madrid Union is now 107 members, probably grown since I put this together. This particular slide comes from last year, so it may have slightly changed. Okay, but the critical thing here is it's a mechanism for being able to register, renew trademark protections via your home country office. Okay, but there's also a mechanism for countries to reject a proposed trademark as well too. If there's an existing business, for example, that already is trading under that name, just because, say, someone in France is using that name doesn't mean that you can bring it to Japan and insist on the right of it. So incorporation, very briefly, we're going to talk a lot about this. You can look at it yourselves, and we will talk particularly about it in the context of MPOs, okay? But this graphic on the side here, I just simply want to emphasize the distinction between governance and management, that people often wonder about this, because of course we've got governance in the title of the course. Management is more kind of operational day to day, and of course it can be even at a quite strategic level. But governance implies a greater oversight. And one of the arguments here, of course, is as soon as you create an incorporated body, you need to create a governance structure around it. Excuse me, I'm going to cough. Not dead, just dried out. So creating a company. Great variance in the legal circumstances here. I already touched on this earlier. But for the most part, countries are moving towards making this an easier thing to do. And you can see on the, still on the remaining teaching website, for example, there's some links to this. The United States is particularly easy to create a company in certain jurisdictions, and if you watch TV or cable TV in the US, for example, you'll see commercials. Put your company on, put your business on a legal foundation, $99, full incorporation in Delaware or something like that. So it's quite easy to do. Where it's easy to do, you often see that people very deliberately create a multiplicity of companies to better organize their business structures. For example, if you have a number of ships, and we keep talking about the shipping instance, it's actually quite an easy thing to do to create a company for each of the ships you own, and then to own each of those companies. Sometimes this is very effective for tax purposes because then very often there's no tax on transferring ownership in a company. But if you were to sell an asset, for example, to someone else, you may have very significant tax associated, what we call stamp duty, for example, in the sale of real estate. So if I was to sell a building to somebody else, I would have to, and the buyer would have to pay taxes on the transfer of that fixed asset. If, on the other hand, the building is owned by a company, I can actually sell the company to somebody. Now, governments, of course, always looking to tax whatever they can, cotton onto this, and sometimes they say that when the beneficial ownership changes, the tax bill still arises. But that's a response to people creatively using corporate form. You may notice, if you pay attention in the credits of movies, that very often it seems that every single movie has its own production company. And it sort of does, because typically a film is, in Hollywood, organized, a film production is actually organized through the creation of a new company. And so you see that one of the challenges is to come up with new company names. So if you watch the credits, you'll see things like, I'm making this up, but I don't know what to call this company, production, for example. So people are always trying to come up with a new name for this particular entity, which doesn't cost very much. And again, because it's a nexus of contracts, you've got so many different people contributing to this particular project. If you actually want to give people what we call residual claimant status in it, that they want to be a part owner in the outcomes of the project, they don't want to just get paid for working on it. They actually want to share in the proceeds if this particular film is a hit. It might be a failure, but if it's a hit, one way to do this is to actually make them a residual claimant, literally an owner in the entity that owns the film venture itself. Another way to do it is to write very complex contracts with a large company, with a film studio, for example, that specify revenue sharing arrangements. They have various issues of kind of trust and trying to write detailed contracts. It's what lawyers call the problem of incomplete contracting. It's quite a difficult thing to do, to write contracts that cover all of the imaginable circumstances. Very often the simplest thing to do is actually to figure out the ultimate share in a project by specifying the ownership structure of the company that owns the project. I'll talk a little bit more about the rise of Delaware and whatnot when we talk about the rise of the American corporation. The governance aspect I mentioned before, this is why I flagged it with that graphic there. So typically the laws that under which companies are created also specify a governance structure. Who is going to be responsible for this thing? Remember, what you're doing is you're creating a fictional person. The problem with a fictional person, of course, is who do you hold to account? You know, you can't throw a piece of paper, which is the deed of establishment of a corporation, into prison. Okay, so in the end, still living human beings have to be held responsible for this undying fictional person. So typically, the incorporation of a company also requires the specification of directors, and very importantly, more than one. Because in most jurisdictions, obviously the regulators think, well, the whole advantage of a corporate form is to bring multiple people together, particularly to share risk and to bring capital from a number of people, and to give a very effective vehicle for sharing the upside and the responsibility for the downside. So if it goes well, you get 20, you get 20, you get whatever percent of the share of the gains from the success of the company. So if only one person could be a shareholder and then a director, why don't they do it directly in their own name? And so we typically see that there must be more than one shareholder, and normally that it requires a governance structure which has directors. Okay, so the minimum number of board members is typically set by the law. Okay, and this incorporation process stands apart from the day-to-day lawmaking, in the sense that it doesn't go to, like it would have done in the past. Every time we created a company, it would go to the Parliament as an act or a bill, or it would be an act requiring royal assent. The Crown, the King or the Queen would have to sign it. These days, the law creates an organisation or an entity which effectively issues permissions to establish companies. And this would be at the national level or the state level. And not-for-profit companies, one of two patterns. They're either created under the same act and so subject to similar kind of reporting requirements, or very often there's special purpose legislation, particularly welfare, hospitals, education, these kind of things. We have this in Japan. There are certain rules around shukyo hojin, so religious incorporations, gaku hojin, educational corporations, for example. Okay. When it's public corporations, there's normally specific laws, and the public corporation meaning that the shares can be traded on the stock market, so we have extra legal regulation there. So the board of directors, I just simply want to emphasize that, because some of you may find yourself sooner rather than later actually being possibly on a board of directors. The first time I had to get my mind around this was actually when I was a student at Australian National University, and the ANU had several entities. The Students' Union, they own quite a lot of real estate. They had various stores and whatnot, the providers of food, vendors, bakers and whatnot. And so there was the Student Union, and then the Students' Union owned a corporation which then contracted with various tenants, for example, in the Student Union complex. And so people who are elected to the Student Union as executive members, or as a postgraduate representative, for example, if we didn't pay attention, you could miss the point that simultaneously what you're actually signing up for was to be a director of this subsidiary company. And that actually brings legal responsibilities for the individual. So you need to be alert to this. Another instance, the University of Queensland, Student Union owns a radio station, and that's organised on a corporate basis. And so students who are really interested in being involved with the radio station, they get themselves elected as the director of the radio station, and they find that they're actually legally responsible for this. And radio stations have the capacity to create enormous legal liabilities through defamation. You only have to damage someone's reputation, and you could be ordered to pay hundreds of thousands of dollars in compensation. And so what is the legal status of directors? So you really need to understand what you're doing. Now, the board of directors has a responsibility to the organization itself, but of course is also constrained by law in terms of its responsibility to the community as a whole. Okay? So the responsibility to maintain the value of and public trust in the organization is critical. If the company acts in good faith, but there are costs arising from its decision, directors have some protection from legal liability. But an old study, it's back in 1996, but it showed that in the UK, amongst directors of companies, 40% of them have been personally named in a lawsuit against the company. So when someone sues the company, they sue the particular company itself, but they also list the names of the individual directors. One of the reasons for this is if a company is in danger of going bankrupt, there's no point suing a company by itself if the company is about to fail, because even if you win in the courts, it won't have any money to pay you. So if you go after the directors as well, particularly if they're wealthier business people, you may be able to find them responsible as well, personally responsible for the failures of the company, and you might have a chance of getting some money back from them. By the way, one of the really sobering things in Japan is if you look at records of successful civil legal actions where people sue other people for their negligence or for whatever, and a majority of people who win in a court case and should be paid by the offending party actually never get paid the amount that the court orders, and a significant minority of them never get anything because people bankrupt themselves. Okay, so you can win and never see anything. And when you've got lawyers' fees and all the rest of it, it gets very, very messy. Even if you've been awarded costs and your lawyer should be paid by the other party because you won, if the other party can't pay, depending on your agreement with the lawyer, you might end up having to pay your lawyer. And so in theory, you've won and you're going to be paid, but in practice, you're not. So when there's a legal entity of a company with limited liability, this is even riskier. So people tend to try and go after the directors as well. So typically, directors protect themselves through liability insurance. Key concept for directors in the Anglo-American notion is that they must exercise due diligence. Due diligence means that they show caution, responsibility, they anticipate problems, that they are sufficiently diligent. And you'll hear this term all the time. Before people sign off on a contract, they say, we'll have to do our due diligence. We'll put it to experts. And this means that there is an enormous ancillary set of services that are accountants, that are lawyers, that are checking things and getting paid quite well for this, because directors and other critical individuals, but particularly the directors in organizations, are very afraid about the legal liabilities that arise. So before they make some significant decision, they're likely to commission expert advice to make sure they have done the due diligence and have a track record of this. Typically, they are paying for that advice with the company's money, okay? But in the process are actually protecting themselves as individuals. So this is one reason why the accountants and a subset of accountants, for example, such as forensic accountants who look into look deeply into the real financial state of companies that may otherwise be presenting themselves on paper as quite well, and the lawyers, why they sometimes explicitly on a retainer for companies to give advice at short notice, but very often are just simply called upon by directors to make sure that the basis of their decisions will be recognized if there's any legal dispute later, as having shown due diligence, of really having done their homework in relation to the issues. Now we need to ask ourselves, why would governments want to keep restricting the use of companies? And historically, why did they do so? Well, the textbook gives plenty of reasons for this. Adam Smith and many others actually had doubts about the use of companies, and particularly the limited liability company. The greatest concern with the use of the company itself, aside from limited liability, is what's called the veil of incorporation, that it hides the face or the identity of people involved in them. Now, it had certain advantages historically. In Western societies, there was considerable prejudice towards religious minorities. And remember, in the UK, religious minorities included Catholics, for example, which were a majority in other places, Jews, for example. So, and the many nonconformists, those who did not accept the religious authority of the Church of England, for example, the early pilgrims who migrated to, who first went and led white settlement in the American colonies, for example, all of them suffered prejudice. Quakers were a classic example. And so they could hide their involvement in a particular business through the creation of a corporation with an innocuous name. Also, sometimes aristocrats who were very much their stature, their status was associated with being, of course, a landed gentry, associated with their manners and M-A-N-O-R, not their manners, but of course they had to have good manners as well too, because that's part of what it was about being an aristocrat. And it was a bit of a snobby thing to be seen to be involved in trade. Now, the reality is that running those great estates, if you've watched Downton Abbey, for example, the British TV series, historical TV series, you realise that many of those grand estates were actually the quickest way to go bankrupt. And in France these days, you can actually buy a chalet, one of these grand aristocratic homes that are in danger of falling down for not much. I read of one case recently of an Australian couple who paid £750,000 or something for a 100-odd room chalet, and it's estimated it'll probably take millions of euros to get the thing back into a decent state. So many of these aristocrats, with the rise of industrialization, although they didn't want to be seen as industrialists because they were terrible snobs, were very often wanting to invest in companies discreetly. And one way they could do this was behind the anonymizing identity of a corporation. So it effectively allowed greater access to capital from people who had good business ideas. More people could be involved who otherwise may have been excluded. And particularly if you had a great idea, but you're on the subject of, and receiving it of prejudice yourself, you could float the idea through the company and attract capital from others. Now, there was a huge amount of potential abuse, and it still is today. Lots of people hide behind what we call shelf companies. It's just a legal entity where the owners, the beneficiary parties are not clearly identified. Hence, we have these registers like we see in the Australian case. We can go out and find out who actually stands behind this corporate identity. And this is this notion of lifting of the veil of incorporation, open share registers, disclosure provisions for significant shareholders. In takeover bids, for example, historically what people would try and do was sneak up on the management of the company, as it were, through using various vehicles to take small stakes in shares, share stakes, and to get to the point of having a controlling sized owning in the shareholding. Later on, when we talk about finance, we'll talk about the and control events. There is this question of a premium for control. That, and this is typically the case, for example, if you are launching a takeover bid for a company, you would offer substantially more than the current share price. So typically about 40% is a reasonable starting point. They'll often drag you up to about 50%, a premium for control. Because the idea is that if you take sufficiently large numbers of shares into your own possession and can then appoint the board and therefore your own management, and presumably you have a vision for how to get more value out of the company, you're going to make major changes, and therefore the people who are current stakeholders want to get compensated to some degree for giving up on being as part of that. Okay. So in order to make sure that premium for control is paid, we typically have rules which specify that if you increase your shareholding over a certain threshold, you have to make an announcement to the share market so that everybody knows. And sometimes it's even more, that if you cross a certain threshold, you actually have to launch a bid to buy everybody's shares. So in many countries, including Japan, 19.9% is critical. If you go to more than 20%, you're required to make an offer to purchase everybody's shares. Now, of course, people don't have to accept the offer, and you don't have to make the offer at a good price, but it's still you're obligated to make an offer. Okay, as I say here, hostile takeover bids often came through multiple shelf companies to conceal the strategic intent of the buyer. This would deny the existing shareholders the opportunity to extract from a bidder a premium for control. Okay, and to bring it back finally then to exit voice and loyalty, which we spent so much time talking about, very valuably, I believe, that if you're only a very small shareholder in a company, you're effectively a price taker. You can't move the share market. Whether I buy or sell 100 shares in Nissan is irrelevant. It'll just happen in no time automatically. I'm a complete price taker. It also means that I've got no incentive to express voice whatsoever. If on the other hand I have 30% shares and I try and sell them, clearly the market's going to think you've got such a large shareholding, you must know that this company's not in a good way. And if someone who owns 30% of the business wants to sell it, probably I shouldn't be buying it at the price that was prevailing before the bid came along. Okay, so in those kind of circumstances, there are really interesting issues about maintaining fairness in terms of access to information in the first place. And we'll talk more about this in terms of disclosure provisions and obligations of companies to update the market in a timely way and make sure that all shareholders are equally informed. And we'll talk further about this, but a key legal obligation are these reporting requirements. And anyone who's taken my design corporate communications class knows this as well. So whether you want to exit the company or stay loyal as a shareholder will depend very much in terms of your sense of where the company is at. Okay, and there is always the concern that the larger shareholders, because they're in a position to exercise voice more directly through being able to have a say in who gets elected to the board of directors, for example, there's a danger that management is more likely to talk to them and not talk to the small shareholders. So those who are either the large shareholders or acting on behalf of them, typically the analysts, for example, working for major investment firms, they might get access to information before the small shareholders do. That's an ongoing issue of fairness in the markets. Anglo-American countries generally have laws which are very, very tough in terms of reporting requirements to the market. And Japan has quite tough rules on that as well too. It's quite closer to the Anglo-American case than it is to a number of European countries, such as, for example, Italy. And so the broader issues of the ownership of shares being very transparent, very knowable, constantly arises in terms of the efficiency of the share market. And so even if we accept a very free-ranging regime, allowing people to create companies, as we see in the United States, there is this very strong sense that we must have transparency. Who stands behind this corporate entity? Because it really helps, particularly the regulators, make sure that the share market, the market in a sense for corporate control, is working fairly. And it's that market for corporate control that's one of the next big issues we're going to talk about. There's already a video on demand that you can have a look for that. That's for a subsequent week after, more than 1 week after this, 2 weeks after this. And we'll come back to those issues. The next set of issues we're going to explore in the next presentation is going to be about agency and theories of agency and principles and agents, and on whose behalf does the company actually act. We've got some hints here with the structure of shareholders in a company appointing the board of directors who then supervise the management, who then supervise work. So clearly in the Anglo-American legal context, the whole way that companies law has evolved makes it clear that the principals are the shareholders and the agents are the managers. But in some legal contexts, and particularly because the board of directors also have an obligation to make sure the company upholds broader community standards, we'll see that it's a more complicated picture. And that's what we'll pick up in the next presentation and in our class discussions next week. Thank you.